Okay, negligence. It is objectively looked at as if from the standpoint of a reasonable and prudent person or the average reasonable person. From a subjective view, it is under the circumstances. So one thing that happens is intelligence and knowledge. Intelligence and knowledge are not taken into account if they are lower than average. And there's some duty placed onto it. So one has a duty to inquire if they encounter a purple stoplight. If they say, well, that's the best I could do, and it's under what a average reasonable person or reasonable prudent person would say, that's not a defense. Part of the reason why the court looks at it that way is because the harm is the same regardless of intelligence. So there's no pass for lower. And the court sees that if the majority has the knowledge, then it is not a defense to not know, like threadbare tires. Driver should know if your tires are bare, it is dangerous. However, if your knowledge or intelligence is above average, it is taken into account by the court. Okay, so the elements of negligence are duty, breach, cause and fact, proximate cause, and damage. And we're going to go through them one by one. So the first element is duty. And breach tells us that everyone has a duty to not harm others. But do we have a duty to certain people is the question. So there are limited duty in a number of cases. And so the test, we're not on the test yet, hold on. So limited duty, even if foreseeable and burden of prevention is seen, sometimes a court will rule no negligence due to policy concerns. So for this reason, this combines with breach, unless there's a reasonably foreseeable plaintiff. Like in Paul's graph, she was not reasonably foreseeable, so they said no duty to the woman way across the station. And again, that's for public policy concerns. But limited, so here's some places where there is limited duty. One of them is negligent infliction of emotional distress. In the old rule, there was no duty, but now, so then it evolved, which most have dropped, the physical impact rule, physical impact to plaintiff. Even if claim is only emotional, that claim will be allowed. But now they look at it as if the emotional harm is parasitic to a physical harm, then you can recover for physical harm, but you cannot recover. The emotional will have to be considered in the compensatory damage for that. It cannot be a separate claim. And so now we look at physical impact versus physical manifestation in NIED claims. And most courts have dropped the old physical impact requirement and now instead require physical manifestation of emotional harm. So there's no across the board rule on this of how much manifestation, but the trend is to require less physical manifestation requirements. So here, direct actions are more likely to succeed, and those are when there is a zone of danger, and this is the majority rule, zone of danger. It also, so if someone is in the direct zone of danger, then they can recover for NIED. There are special cases, the death telegraph, where people give you the wrong message, you think someone's dying. That is a special case. Also, the mishandling of loved ones' remains causes distress even though there is no zone of danger or what they would consider bystander, which we'll talk about next. Special relationship situations. This is this is a minority and not many, but they're pretty specific. So a therapist molests a mother's children. The mother can recover because there's a fiduciary relationship between the mother and the doctor. If a doctor misdiagnoses a woman with STD and encourages her to tell her husband, there can be an action from the husband against the doctor. The doctor tells a mother that her baby is stillborn. There can be a direct action from the mother, but only a bystander action from the father. The bystander actions are what we call third-party actions. This is a thing in LaChusa jurisdiction. The requirements are some jurisdictions use these elements we'll discuss as guideposts, some use them as elements. But the plaintiff must be closely related to the injury victim. The plaintiff must present at the scene of the injury-producing event and is aware the injury is happening, so it can't be from hearing it, or they have to be present and they have to be aware. And the plaintiff, as a result, must suffer serious emotional distress that is more than if they were just a disinterested witness. So that is the thing jurisdiction. The other jurisdiction is the zone of danger, which we already talked about, which is considered direct anyway. But this would be like if the plaintiff had been in a crosswalk and then a car comes rushing through and slams into their friend, the person in the crosswalk was in the direct zone of danger and can recover. But he's still a bystander. Okay, some other limited liability are absent failure to act or rescue. The rule is absent no special relationship, there is no duty to rescue. This is called sometimes no duty to act, even if rescue would be easy or safe. This is controversial, but it is widely followed. There are exceptions to this, and those exceptions are special relationships, and special relationships create a duty to reasonably rescue, and they are generally when there is a power differential in the relationship. So employer-employee, parent-child, jailer-prisoner, common carrier like a train or an airplane and their passengers. This can also be with spouses. Here's some hypos to help us figure it out. And they're also above and beyond what we just talked about. You are speeding and strike a pedestrian. You could easily move them, and another car is coming. So because this is a second harm situation, you have and you created the risk, you have a duty to help as long as it's reasonable. Your negligence didn't cause the accident, but an earthquake made you hit a pedestrian. Well, your car was the instrument that caused the harm, creating the special relationship and duty. So again, as long as reasonable and safe, you have a special duty to act. A dad has custody of children. Grandparents have a mother who is mentally ill. Grandparents ask to have the kids and promise to protect them. Mother attacks the children. Grandparents have a duty based on a promise. So you can create a duty based on a promise. Hiking, you see someone laying on the base of a cliff, you carry them caveman style by their injury and you aggravate it. This is a duty because your rescue is not reasonable. Hiker is unconscious, you run for help but decide not to. As long as the hiker wasn't relying on your rescue and didn't knowingly rely on your rescue, you don't have a duty. But if the hiker is crawling for help and you tell them, hey, hold still, I will go get help, then you do have a duty based on your promise. Jurisdictions have conflicting opinions on if a spouse is abusing children, does the other spouse have a duty to help? Our sense of justice says absolutely, but that is not what the courts consistently say. If you do decide to rescue, it must be reasonable. And a hint, again, for a special relationship is look for control and responsibility. The stronger these two are present, the more likely the court is to call the relationship special and impose a duty. If I didn't say before, duty is a matter of fact. Oh, no, sorry. Duty is a matter of law, and therefore it is decided by a judge. There's some other limited duty claims. and one is wrongful death. That's, again, a parasitic tort claim where loved ones of a descendant's death allege that a descendant's tort that the plaintiff's tort caused the descendant's death, causing harm to their loved one. This must be based on a tort claim, so it's a piggyback, parasitic, in other words. This is generally very limited range to the plaintiffs by statute, so sometimes spouses, children, parents, it's a line in the sand, so it's ever changing, but classically it's the father, breadwinner, husband, although it's expanded a little from there. Traditionally restricted to the loss of financial support and services from the descendant, but increasingly it is extended to general damage for loss of companionship. And I just said this, but so this traditionally will bring loss of traditional anticipated support, loss of services like a mother or stay-at-home dad. Loss of companionship is the modern trend. Then we have wrongful birth. This is a parent's cause of action for the cost of raising a child when the defendant's negligence deprived them of the choice to avoid conception and have an abortion. Most jurisdictions allow this, at least where the child is born with health problems. Courts generally allow special damages, but are split on whether to allow general damages. Courts disallow double recovery for wrongful life and wrongful birth. Wrongful life is the child's claim, and it is also parasitic. It asserts negligence led to the child being born who otherwise would not have been born, and seeks damages. Most courts reject the wrongful life cause of action. A few jurisdictions have allowed it, but generally only for special, which is out-of-pocket, or medical expenses. There's no general damages for pain and suffering. Policy interest is to affirm life. Judgments are problematic, saying non-life is better than life. And then we have the unborn, which traditionally they have not allowed recovery for, but public policy says it's illogical to have liability for harm for an unborn child, but not for the death. So the majority injuries to a fetus are recoverable, even if never born. A baby that is born alive can recover from injuries, and the mother, even if she has a stillborn, is able to recover for her own injuries. But the majority now lets recovery for stillborn. Limited duty for owners and occupiers of land. So we have three different types. We have trespassers, licensees, and invitees. And trespassers, in the traditional rule, a landowner or possessor had no duty to a trespasser, except if there is a duty to a trespasser regarding places it should be anticipated that the public will be. So a railroad owns a railroad track and it goes across the street. Obviously there's going to be people and traffic there, so the railroad is responsible for that piece of their property. And if a trespasser's presence has been discovered, there is a duty to be active but not passive operations. So restatement assigns no duty of care to flagrant trespassers unless the harm is intentional, willful, or wanton, and unless the flagrant trespasser appears to be impaired or helpless or unable to protect themselves. Flagrant. We got questions on what does and does cause that. Anyway, so that's trespassers. Licensees. So licensees are coming as like a house guest, really. It's one on another's property with permission, but generally not for business purposes. Most generally, they take the premises of his host as they find them. So this is the broken sink in the bathroom, or the refrigerator that shocks you. The host has a duty to warn of hidden dangers that the host knows about, but the licensee does not. He does not have a duty to fix them. He does not, so not to make the property safe, but he does have a duty to give a warning. Regarding active operations, the owner must act with due care towards this licensee. Whether they are actually discovered and their presence should reasonably be anticipated. And this was the walking through the corn. The guy knows the guy's walking through the corn. He decides to thresh the corn anyway, and he gets fatally injured. Not okay. The invitee is there for the owner's purpose. So these are invited to the property for a business purpose, or those on the property open to the public. It could also be a church building. There is generally no duty limitation for invitees, thus landowners owe invitees a duty of care. That does not mean landowners are always liable to invitees, but the plaintiff has to establish a breach of duty to establish duty. Rejection and merging of these categories. So some jurisdictions still maintain these three categories. California and other jurisdictions reject them. They do require a duty of care for all persons on the property, which is lame. And then some jurisdictions require a duty for invitees and licensees, but they limit the duty to some trespassers. And this is the closest to the restatement approach. So that's duty. Woohoo! Now we have breach. Breach is a question of fact. It looks at reasonableness. So the learned hand approach weighs the gravity of harm with the foreseeability of harm against the burden of prevention. So we're going to make the base the burden of prevention. We're weighing gravity of harm, gravity and foreseeability against the burden of prevention. Negligent or unreasonable conduct or failure to act exists if gravity of harm and foreseeability of harm is greater than the burden of prevention. Let me say that again. Negligent or unreasonable conduct or failure to act exists if gravity of harm and foreseeability of harm is greater than the burden of prevention. So, like, is the burden a practical way to live life? Like the golf club in the yard. Is it practical to say nothing can be left in your yard lest you have a horrible tort claim against you? So some things that go into the reasonableness, like, is it a custom? Were you keeping a custom? Were you violating a custom? This is not proof, but it is evidence, otherwise known as dispositive, not dispositive. Going with custom, however, can be dispositive, and not following custom may be okay if it is a respected school of thought. Even this is the wrong page, but it's good that I know that, right? Okay, so let me switch that back up. It did flow quite well. So after that, we're gonna get into some sources. No, that's not right. We're gonna get into other evidence. Going with custom. Here we go. I'm gonna waste your time and mine. Okay. And I'm all messed up. Hopefully this works. Okay. So other factors. We have the emergency doctrine. Did you act like a reasonable person under emergent circumstances? So you get some leeway. Physical limitations and exceptionalities. Physical characteristics and abilities are taken into account. Again, not lower intelligence, but if you're blind, you're not going to be given the same standard as a sighted person. If you are a astrophysicist, you're not going to be given the same as a farmer if you're talking about, I don't even know what you'd be talking about, but anyway. And not that farmers can't be brilliant, because they totally can be. Anyway, so children are also, they are looked at for reasonability of age, intelligence, and experience. There is an exception if they are doing dangerous or an adult-like activities. Then they may be held to the same standards, such as like shooting a gun or snowmobiling. Anyway. Insanity is not looked at. The minority says it might be a possible factor if it was sudden onset. And some places say there's a possible exception if it's in contributory negligence claims, it may be considered. Courts like to favor the injured party being able to use the insurance system to recompensate them for damages. The professional exception to this duty breach. So a professional with mainly licensed is going to be looked at, or do they meet the minimum skill of those in good standing with that license would do. Same with the specialist. They are held to a standard of a specialist with the minimum skill in good standing. So there's some caveats of specialties. So we've got legal breach. They have a learning skill and ability of a member in good standing. Were they working for the best interest and with reasonable due care? We have medical malpractice, and this is where I was about to talk to you about. So medical malpractice, were they going with custom? Custom is dispositive. If they were going with custom, they're pretty much good. If they were not following custom, it may be, this might still not be, this might be with informed consent. Yeah, if they were not following custom, it may be okay if they were going with a respected school of thought, even if it is the minority. Suits generally require really expensive expert testimony, and it's hard to break the conspiracy of silence in the medical community. So then we have medical malpractice, but specific to informed consent. And here, failure to inform of a material risk prior to obtaining consent is one of the elements. So a material risk in the majority is a reasonable person would attach significance to the info. But the minority says, well, even if most reasonable people wouldn't, if the plaintiff would have found this info significant, even if no one else did, then it is material. It also, the informed consent issue must have causation. They would not have consented to the treatment had they known about what was not in the informed consent. There is no causation of harm if what was left out is common knowledge, if there was a therapeutic reason not to disclose, or if the doctor was in an emergency situation, there wasn't the possibility to get consent, and so the doctor had to act. They also imposed locality rules, and the jurisdiction looks at like areas. So the locality rule is they look at other people in your locality. The national approach, especially for specialists who have national licensing, they look at other specialists of their same caliber. And then others look at same or similar places, so small town to small town. And this is trying to defeat the conspiracy of silence that might be in a local community, but not in a community outside. And then they also look at damages that were caused by the lack of informed consent and what happened due to that. So, next. Sources of specific standard of contact utilized in determining breach. Fun stuff. So, reasonableness is determined by a trier of fact, and that is the jury. Reasonable might be determined by a judge if it is an issue of law. Rules of law are established by the appellate court, and statutes and regulations adopted by the court. So statutes are controlling law. And anyway, so we're going to talk about negligence per se, which means it's just there. It's there. It means negligent by statute. So negligence of a statute unless it's excused by a judge. So if there is negligence per se, you broke a statute, therefore there's negligence. So it is negligent unless a judge says, no, as a matter of law, this is not right. Or it goes to trial. You say, yes, this says you broke the statute, but I was driving through Central Park because I had to stop a bomb that was going to blow up the whole city. That would be a rebuttal, and then the jury would get to decide whether it was reasonable or not. So it just, and then other jurisdictions say it's just some evidence of negligence. Breaking a statute doesn't mean it was negligence, it's just another piece of evidence. So why statutes? Well, public policy says that a reasonable person will obey the law. The legislature impliedly intended a civil remedy. The statute gives people more rights, and they want us to have rights, maybe. Statutes at least provide a standard of conduct for society, and statutes can be helpful in determining breach of duty. So the statute, so in order to say negligence per se, you broke a statute. What needs to happen is the plaintiff has to be a member of the class that the statute was meant to protect. The injury happened that the statute was meant to protect. And the violation proximately caused the injury. So, protected class, meant to prevent, caused the injury, proximately caused the injury. So proof of negligence, there's direct evidence and there's circumstantial evidence. So the circumstantial evidence, now we get to talk about res ipsa loquitur. The thing speaks for itself. So per se, say statute. Per se, say statute. Res ipsa loquitur, the thing speaks for itself because you're looking at it and it speaks for itself. Res ipsa loquitur. The prereqs for res ipsa loquitur are: must have an event that does not normally occur in the absence of negligence, like a big flour barrel falling out of a window. The instrumentality causing the event must be under the defendant's exclusive custody or control. So in the case, the flour was in the warehouse, it was under the owner's exclusive control. He did have employees, but those employees were his. Exclusive control. This runs into a problem if there's multiple defendants with control. Most plaintiffs will not be able to show exclusive custody and control, exclusive custody and control, res ipsa loquitur, exclusive custody and control. But the minority rule says in highly integrated services like surgery, the court can see them as a team. This is almost only used in med-mal cases. And the injury must not be due to the plaintiff's own conduct. So before 1970, contributory negligence was a nuclear defense, but now we have comparative negligence, which will just split it and reduce it. So procedural consequences. The majority rule is res ipsa loquitur creates some inference of negligence. The judge decides if the prereqs have been met. What does this happen in absence of negligence? Was it under exclusive custody and control? Was this due to the plaintiff's own conduct? And then the jury decides the weight of the evidence. So he only gets it to the, okay, this is a question of fact and no further. The California approach, it's not a rebuttal and it starts at the presumption. So res ipsa loquitur has occurred, the thing speaks for itself, the judge says fine, goes to the jury, and the jury can bring it from the very beginning of matter of law, or matter of fact, on. In the pure rebuttal approach, res ipsa loquitur creates rebuttal presumption of negligence and shifts the burden of proof. This is a pro-plaintiff approach. So in the pure rebuttal approach, it could be anything. It starts at absolutely zero, and the defendant has to show exactly to even get into the facts. There's no presumption. The presumption is negligence, and they have to fix, whereas the presumption is negligence. Okay, cause and fact. Not moral, purely factual, always yes or no. But for causation. A party is a cause in fact if, but for her tortious conduct or failure to act, the accident would not have occurred. We do not require that the defendant's negligent act be the only cause or even the primary cause, just a cause. Proof level. P has a burden of proof to prove more than not negligence caused the injury. So there's the loss of chance causation, and that's a statistical chance for proof level. This is not allowed by majority. In minority, we're allowed. It is generally limited to med-mal cases. And it may also be limited to special damages, which are out of pocket. Loss of chance. Then we have joint and severable liability. Socializing loss so somebody can pay. Where multiple defendants' conduct is each a proximate cause of the plaintiff's indivisible injury, each of the defendants is liable for the entire amount. Joint severable liability. So one person pays the piper even if it's for a lot of people. It does not allow double recovery because once plaintiff has recovered all damages from any defendant, the plaintiff's claim is satisfied and the plaintiff cannot recover further from other defendants. Major cause of fact test. So this is our biggest area of cause and fact. So there's the traditional substantial factor test, majority, but rare. The hypo for this is two fires that combine, and then you can't tell which fire burned your house because they were both going. And so two or more forces combine to bring about harm. Next term. Yeah. Defendant is responsible for only one of them, which was a substantial factor in bringing about the harm. Each force would have been sufficient to bring about the harm alone at the same times. Alternative causation approach. Evidentiary boost for plaintiff. Hunting party to shoot this one person in the head, both accidentally. Only one shot hit him. The plaintiff is injured by the negligence of only one of multiple defendants. All the defendants acted negligently toward the plaintiff, but the plaintiff cannot establish which defendant caused the injury. When three elements met, burden falls to each defendant to prove they did not cause the injury. Enterprise liability approach. This is the California minority. It generally needs a manufacturer. The plaintiff is injured by the negligence of a manufacturer making a product. The market consists of goods that are in all material respects identical, no consequential difference. The plaintiff has named the defendant representing a substantial share of the market, and P reasonably cannot establish which manufacturer made the product that injured her. Then, the burden is shifted to each defendant named to prove they did not cause the injury. If they cannot prove they did not cause the injury, each defendant's liability is limited to its share of the market. So this is like the prescription class, the hypo we were talking about. And then we have the California substantial factor test. CA standard jury instructions use substantial factor language instead of but for. But case law indicates it is consistent with the but for analysis. Exception in asbestos cases and possibly other toxins in California, substantial factor can mean a part of the cause even if not the but for cause. Sounds more like proximate cause to me. Okay, proximate cause. Woohoo! Here's the strategy. Step 1. Is there a foreseeable plaintiff? If so, go to duty. Step 2. Proximate cause analysis. We can use the reasonable and foreseeable approach. This is the clearest proximate cause issue. We can do the direct cause approach, restatement third approach within risk approach, hindsight, Andrew's rough sense of justice, and we can analyze potential intervening causes. The clearest method is the reasonable foreseeable approach. So, foreseeable is always coupled with reasonable. The defendant is generally liable for a reasonably foreseeable injury, even if it occurs in an unforeseeable manner. So the train loop where he put it in reverse, he ended up hitting the train anyway. There is an unforeseeable plaintiff problem, and this goes to duty. It goes to a duty issue, arguably no harm to plaintiff if it is reasonably unforeseeable. Thin scale rule. Defendants are held liable for all physical results, whether foreseeable or not, resulting from foreseeable personal injury to plaintiff. So it must be injury to a person. And there must be a direct chain of causation. The first structure rule of New York, only one house can recover after a negligent fire. That's stupid, quite frankly. Approaches, not rules. Approaches frame an argument. So we're talking about framing the argument. Here they are. Direct causation approach. In cases taking the direct causation approach, proximate cause exists if injury is a direct and natural consequence of a defendant's conduct under the existing set of circumstances rather than the result of an independent intervening cause. Plank falling on the ship, there is a spark. Direct cause approach. In cases taking the direct causation approach, proximate cause exists if injury is a direct and natural consequence of a defendant's conduct under the existing set of circumstances rather than the result of independent intervening causes. The reasonable foreseeability approach. In cases taking the reasonable foreseeability approach, proximate cause exists only if plaintiff's injury was reasonably foreseeable result of defendant's negligence. This is the dominant view. It's the majority view. It's the one the bar looks at. This is the wagon mound, the ship oil, with cotton in the water, with fire, reasonably foreseeable. Result within the risk restatement. Defendant is liable if the harm is from the type of risk that made the actor's conduct tortious. I'm not sure which one. Result within the risk restatement. D is liable if the harm is from the type of risk that made the actor's conduct tortious. Zone of danger approach. Was this within the zone of danger? Some people say that's Paul's graph, even though that was a reasonable foreseeable issue. Hindsight restatement approach to proximate cause. In cases taking the hindsight approach, proximate cause exists if in hindsight it is not highly extraordinary that defendant's negligence brought about the harm. So hindsight, highly extraordinary. This is a pro-plaintiff approach. It's looking at better for public policy. If negligence is found, policy is concerned with keeping justice even-handed. Then we have Andrew's rough sense of justice. Practical politics and good and fair for society. Now, proximate cause with intervening causes. General rule. An intervening cause is superseding, thus relieving the defendant from liability if it was not reasonably foreseeable. So, intervening cause of a hurricane in Miami, reasonably foreseeable. Does not relieve defendant. Hurricane in Portland, Maine, not reasonably foreseeable. Might get the defendant, just free him of liability. Contributory negligence is usually foreseeable, not always superseding, but can be. What are not intervening, superseding, intervening causes? Sick for short. Second accidents. D1 causes negligent harm and second accident then happens. Generally, second is considered reasonably foreseeable. No sick. Escape attempts. Falling out of a train, you grab someone, that is reasonably foreseeable. No sick. Rescue attempts. If reasonably foreseeable, D1 will likely be responsible for rescuer's injuries, not superseding. This is danger invites rescue. Negligence by doc after negligent injury. Doc aggravates injuries, reasonable foreseeable. D1 creates need for medical help. General med mal is not sick, so D1 is on the hook. Superseding causes, overlooking original negligence. If it's not reasonably foreseeable, then it's superseding. So D is off the hook. Special circumstances, fire spreading, New York arbitrarily limiting. Majority says no. Criminal intentional misconduct. How foreseeable is the criminality of the area can be taken into account. Pushing off a train in a violent area, it probably won't supersede because you knew it was a violent area. In a cornfield where it doesn't usually happen, probably not reasonably foreseeable. In which case, it wouldn't supersede. If it's foreseeable, it won't supersede because you knew it could happen. Anyway, serving alcohol, there is strict liability for serving minors. Commercial establishments are liable. Social guests to host, most say no. Suicide as a significant intervening cause. The majority says suicide is a superseding intervening cause. I don't know what that means, so I'm not going to tell you what I said. The minority says it could be a superseding intervening cause if it was an irresistible impulse, might be different. The minority of the minority says sudden frenzy created by an irresistible impulse that came from an accident that could still be proximate cause from the accident. So maybe it can be tied back to the injury. All right. Damages, we're at the end. Damages. In order to recover in negligence action, there must be all 5. Duty, breach, cause and fact, proximate cause, and then damage. So they're special. Which is out of pocket. General, this is vague. Pain and suffering. The philosophy is, there's philosophies. Are we looking back to right the situation? Are we looking at the plaintiff to make them whole? We're doing all of those. The English rule. Loser pays attorney's fees. American rule. Each party pays their own costs. D usually insurance pays. P most times is on contingency. Some statutes come with attorney's fees. Disabled School Act, we're suing for performance. Oh, so some statutes say you'll get them. Anyway. Collateral source rule. For purpose of mitigating damages, D may not introduce evidence that a third party provided P with money related to P's injuries. So if medical bills are discounted, you still get to recover for the whole medical bill. More than 50% of jurisdictions have gotten rid or modified this statute by tort reform because they do not want anyone to get a windfall. Most insurance say that if expenses paid in full, plaintiff is compelled to owe it to insurance that originally paid. There is a duty to mitigate. Mitigation of damages rules. Plaintiff cannot recover damages that could have been avoided by reasonable conduct by P after D's misconduct. Torn cartilage in knee, surgery, or lifelong pain and suffering, you get to decide. Courts typically see as electing not to have surgery is a reasonable election you can take. Punitive damages focus on defendant. Discovery into wealth of defendant needs to be allowed for punitive damages. Some jurisdictions split trial and damages. Usually these are rare and small unless there is despicable negligence. Here's a sketch. Often associated with intentional torts, may also be attached to negligence if regarded for safety sufficiently extreme. Not compensatory, these are designed to punish and deter. Courts typically allow D's wealth to be considered. Many jurisdictions have enacted tort reform limiting punitive damages. Many jurisdictions split punitive damages between plaintiff and the court, but not NCA. Court making money. Ick. The Supreme Court now holds punitive damages subject to constitutional analysis. Generally, they cannot exceed a 9-to-1 ratio with compensatory damages. Factors include reprehensibility of conduct, most important. Ratio with compensatory damages. Officially, this is 9-to-1, but 3-to-1 and 4-to-1 have been overturned as unconstitutional. The bigger the compensation, the smaller the ration allowed. Comparison to civil or criminal monetary penalties is the least important. And nominal damages just make a point. Affirmative defenses for negligence. We are so close to being done. These do not go with intentional torts. There is contributory negligence. Only a small minority, 4 states, use this as a defense. In contributory negligence jurisdictions, even a small degree of contributory negligence completely negates the plaintiff's claims. Because the doctrine's harshness, courts create a lot of exceptions. Last Chadden's doctrine, contributory negligence jurisdiction. If the defendant had the opportunity to avoid the accident after the opportunity was no longer available to the plaintiff's contributory negligence does not bar recovery. Hypo, a donkey is hobbled in the street. A carriage comes too fast down the street to stop. Donkey sues horse, uses contributory negligence. Donkey uses last clear chance to counter. The horse had the last chance. Comparative negligence. There are 3 approaches. The pure approach, purely a percentage of blame. Plaintiff approach, this is plaintiff friendly. Hypo, P is very contributory negligence. Jury finds plaintiff 95% at fault, D 5% at fault, but the damages were $5 million. Even though P is 95% at fault, he will still recover 5% of $5 million, which is $250K. There is the second approach is offset approach, assumes some facts but the other driver also suffered $100K of damage and cross-claimed. In most jurisdictions, the damages, we're still on the pure approach. In most jurisdictions, the damages will offset plaintiff entitled. But this offset approach, because it doesn't help the plaintiff if insurance is paying. California has rejected, each pays each other, and that's it. Less than approach. P only gets to recover if his own negligence is less than D. So P has to be 49%, D has to be 51%. No, that's not true. This is less than. If he's less than, he gets to recover. Not greater than. So there's actually 4 approaches. No, I'm wrong again. Glad I'm doing this. Less than approach is 49-51. Not greater than can be 50-50. This helps because a lot of juries say you're both equally, and in a 50-50 jurisdiction, then the plaintiff gets to recover 50%. In a less than 50-50 means that the plaintiff gets nothing. And then if you have more than one defendant, there's 2 ways to look at it. A few jurisdictions say P's fault must be less than any defendant. So if D1 is 60 and D2 is 10, but P is 3, then P would not get to recover because he's not 30% is more than 10, so no recovery. But most jurisdictions add the D's percentages together, and as long as P is less than the total of D, they can prevail. That's the majority. Assumption of risk only applies when D's negligence already exists when the plaintiff perceives danger. So these are affirmative defenses. Assumption of risk. Hypo, not applicable when P is walking in a crosswalk and reasonably expects the car to stop, but would be relevant if P sees D driving at a dangerous speed close to the crosswalk and decides to try to make it across anyway. There is also express assumption of risk, which would be like skydiving. There is implied assumption of risk. This could be going to a sporting event or playing a sport. 2 requirements for implied for like things smoking, subjective appreciation of risk, and voluntary encouraging of risk. CA has now swallowed up implied assumption of risk in comparative negligence. This is a trend, causing it to be handled like comparative negligence. And that is my whole negligence outline. Let's see if we can do intentional torts in 9 minutes and make this an hour. Battery is an act with the intent to cause a contact with a person which is harmful or offensive, or with intent to cause the imminent apprehension of such contact causing a harmful or offensive contact with a person. An act is an assertion of will manifested in the external world. Intent is a term of art requiring desire or substantial certainty, done as an act of volition of will. Assault is an overt act with the intent to cause a contact with a person which is harmful or offensive, or with the intent to cause the imminent apprehension of such contact, causing a reasonable imminent apprehension of such contact. Woo! Reasonable apprehension is apprehension has to be reasonable or no recovery is the majority. The restatement says even unreasonable apprehension is sufficient. False imprisonment, an act with the intent to confine within boundaries, causing the confinement of plaintiff within boundaries. The plaintiff's awareness of the confinement is a must, unless the plaintiff is harmed by the confinement. The boundaries can be physical barriers, force or threats against person or immediate family, threat to property, asserted legal authority. Then we have intentional infliction of emotional distress, which is not one of our 5 main ones. Its elements are an extreme and outrageous act intentionally causing severe emotional distress. There must be physical consequences in the minority and physical in the majority, but not required in the majority. This is California. Extreme and outrageous to a reasonable person, but special sensitivities can play into decision, children, or pregnancy. Intentionality, act causing distress had to be known by the offender that victim was present, and victim has to be physically present. Bystander restatement. The conduct was directed at the bystander or their immediate family. Bystander suffers bodily harm as a result of his or her distress. Recklessness. The deliberate disregard to a high probability that severe emotional distress will follow. Causing has to be evidence that severe distress came from the event or made it worse. Trespass to land. We're back to one of our main 5. An act with the intent to enter or remain on land, or failure to leave when consent expires, causing, but for, the entry or remaining on land in which the plaintiff has a possessory interest by the defendant, a third person, or a thing. Mistake is not a defense. Transferred intent applies. Microscopic only applies if it accumulates in the majority. Above and below. Majority, you own what is practically usable. Minority, you can create reasonable intrusion of use and enjoyment. And restatement requires both practical usability and reasonable intrusion. Below, most urban owners don't own much below. Most rural owners have more rights below. Damages tend to be nominal because they tend to set a boundary. Private nuisance involves intrusion on use or enjoyment of real property, in contrast to trespass to land, which is interference with exclusive possession of real property. Trespass to chattels. Elements are an act with the intent to affect a chattel, causing Damages to a chattel in which plaintiff has a possessory interest or loss of its use for a substantial time. An injury to plaintiff or person or thing in which the plaintiff has a large protected interest. The possessor can bring the tort. It doesn't have to be the owner. Then we have conversion. You break it intentionally, you bought it. Negligence is more common than intentionality. Not necessarily damage can be interference. This is a longer one. An act with the intent to exercise dominion over a chattel, causing an interference with the right of the plaintiff to control the chattel, and the interference is so serious that the defendant may be justly required to pay the plaintiff the full value of the chattel, damaged beyond market value. Dominion and control for a period of time, substantial harm done, inconvenience and expense caused by the plaintiff, the defendant's intent to assert a right to the defendant knows is inconsistent with the plaintiff's right to control. There is an affirmative defense of good faith. Damages are compensatory, basically market value. Majority is the highest value from the time of tort to replacement. Minority says the highest value at time of tort to trial. And you get what you buy. Good faith purchasers. Stolen. Person who buys stolen property is still liable for conversion. Title doesn't pass from stolen chattel. Original owner retains superior claim. Fraudulently obtained. Contracts to sell are not void. Contracts to sell are voidable. Once the property has been transferred substantially, it is too late. Original owner cannot go after subsequent owners. Transferred intent. Attempting one tort resulting in another. This is only between the 5 old trespass torts: battery, assault, false imprisonment, trespass to chattel, and trespass to land. 3 variations of transferred intent. Same tort, different person, different tort. Same person, different tort, different person. Damages, compensatory, or special in general, punitive and nominal. We already talked about those. Substantive defenses, a defense showing one or more elements were not met. Claim done. Affirmative defenses, consent. Types are express and implied if a person would believe there was consent. Custom may dictate consent. Scope of consent. When one consents, they only consent to the type of context included in the consent. Medical, typically treated as batteries. Historically, medically emergent privilege may supersede. Limitations on consent: you can't coerce, it can't be fraudulently induced, it can't be asked by for people of lack of capacity. There can't be consent for illegal activities like street fighting. Some states' consent is invalid if a rule is made to protect the victim. Other states it is valid. Self-defense. Any person can use reasonable force to defend themselves against immediate threat of battery. This cannot be retaliation for the future. The threat must be reasonably immediate. If the attacker retreats, you cannot follow. Rules of retreat. Majority. Stand your ground laws. Minority is retreat. Caveats. In self-defense, if someone else is hurt by mistake, it is generally excused. Insults or verbal threats are not enough to allow self-defense. If verbal threat is known to precede the violence, it can be a reason. You can't use a human shield. That's stupid. Defense of others. You may use the same force to protect others as you would use to protect yourself. Mistake. If it's a mistake, some use the stand-in shoes doctrine of liability. The mistake is excused provided it's reasonable. Defense of property, reasonable force. Not deadly, but it could or anything that could cause seriously bodily injury. That's different if it's night or day. Daytime, it needs to be reasonable. Nighttime, it's a little more anything goes. Warning signs. Minority, warning signs on the property. In the minority, warning will prevent liability. Majority, still liable for unreasonable force. Peaceful entry. Daytime, you must request them to leave. Nighttime, all bets are off. You cannot use force to recover real property. Must use legal process for that. Recovery of property. Reasonable force to recover a chattel if you are in fresh pursuit. Passion. Once pursuit is not fresh, legal remedies are expected. Special circumstances. By statute, most states allow detaining for reasonable time if a store has probable cause. Public necessity. A person has a complete privilege to interfere with property rights if one reasonably believes it is necessary to avert public disaster. B. Mistakes are forgiven if reasonable. Private necessity. A person has the privilege to interfere with property rights if he reasonably believes reasonably believes it is necessary to prevent serious injury to a small number of persons or property, but the person must compensate for any damages caused. No punitive damages. Thank you very much. This has been my intentional and negligent tort outline.